We're in for a treat. And the members of New York City Fair's executive team are here too. Mary Krasner, Lou Turo, Randy Bolton, Jim Karp, Lynn Decker, Marion Resnick, Michael Bolton, Janet Turo, Carlene Braithwaite, and Rochelle Kovanonsky. Special thanks to Matthew Resnick for stepping up to be our Zoom master for this evening. Here's Marion with the rules for tonight's town hall.
Good evening. Thank you for coming. My name is Marion, and it's my job to outline the rules for this evening. The goal is to create an orderly and respectful format. We've invited our presenters to try to make sense of who is in charge of what, and not always a straightforward process. Our moderator will ask as many of the questions you submitted as there is time for. There is a chat box for questions and comments. It is being monitored throughout the evening, and every effort is being made to answer. The town hall is scheduled for 90 minutes. The meeting will be recorded and posted on YouTube in a few days. If you do not want to be recorded, please turn off your audio and video. Everyone will be muted except the presenters and the moderator until the end, when there should be a little time for those on the telephone to ask a question. We ask that you keep your questions to 1 minute. You will be muted if they are longer. Please take turns speaking. In the unlikely event that we are Zoom bombed, the Zoom master will turn off everyone's audio and video until the problem is solved. We should be able to resume at that point. This format only works when the audience is muted until the question period. If you are on the phone, use *6 to mute or unmute at that time. Your cooperation is appreciated. Now I would like to turn this over to Mary, who will introduce our speakers.
Good evening, everyone. I'm Mary Krasner, and I want to introduce our presenters I'm going to start with some very condensed bios in the interest of time. As you heard, Catherine Marlay, Kate, is a Deputy Commissioner of Policy and Program Development at OPW. She's the leading negotiator and point of contact with the Federal Center for Medicare and Medicaid Services, we refer to commonly as CMS, as well as the New York State Department of Health. This is to ensure critical funding and develops administrative infrastructure to provide long-term supports and services at OPW. She has a dual master's from the University of Texas at Austin and a Master of Public Affairs from the LBJ School of Public Affairs in Austin. Megan O'Connor-Herbert is Deputy Commissioner for the Division of Quality Improvement, where she oversees the Bureau of Program Certification, the units responsible for incident management, continuous quality improvement, data analysis, and evaluation. She's recently returned to OPWDD from Care Design, where she was Chief Administrative Officer. Megan began her career as a DSP. Yeah. With a BA from Siena College and a Master in Social Work from SUNY Albany. Beth Haroules, last and certainly not least, is a senior staff attorney at the ACLU of New York. She handles a broad variety of issues regarding civil rights and civil liberties, including disability justice matters. She is lead counsel in the Willowbrook class action litigation and the Hirschfeld versus Health and Hospitals Corporation of Kings County, the conditions litigation. She served as a member of the advisory council to the Supported Decision-Making New York Project. She's a graduate of Harvard and obtained her law degree from Boston University. So if we could begin, Kate, if you would, before we get to the changes, can you briefly explain the home and community-based waiver, HCBS, that the federal government created?
Sure, that is an excellent starting point because, well, first of all, it's near and dear to my heart. But secondly, it's a really, really important agreement that funds a really enormous piece of the services that happen in New York State for individuals with IDD. So a home and community-based waiver, it was set up so that individuals had a choice between community-based services and institutional services. What the waiver does is it's an agreement between the state and the federal government, and it governs HCBS, home and community-based services. What it allows you to do is to waive goodbye to certain rules that apply, sort of more broadly in the Medicaid world. What it really boils down to, particularly for us, is that there's kind of two main buckets, if you will, that fund OPWDD Medicaid services, so not family support Medicaid, and that's HCBS Waiver, and we have state plan. We have, for example, ICF services are a state plan service. So that's kind of an important construct to understand as we get further into the discussion tonight. I will say with quite some pride that we have one of the very largest waivers in the country. And I think only California might be larger. And, it's near and dear to my heart.
Can I just point out, if for the interest of simplicity, that's why we get money from the federal government. If we did not participate in this, they would not be sharing in the costs of our programs.
Exactly. So no, that's a very good point. So by way of that agreement, it's a very big document. It's on our website. It's 300 plus god awful pages. But the bottom line is that is how we bring in federal money. And for New York State, that is half the money. So for every dollar spent on an IDD HCBS service, it is because of that agreement that we get 50 cents on the dollars from the federal government. So we could say we don't want the agreement, but then we would have literally half the cash. So it's a very important agreement and a very important funding stream for just about everything we do.
So it is a very good idea for us to make them happy or not make them unhappy.
Yes.
Which brings us to the fact that they are now imposing new rules called the settings rule.
Yeah.
And if you would explain that a little bit, that would be very helpful.
Sure. This is one of those new rules, not so new. It's an odd duck. And I'm sure others will want to jump, like I'm sure Beth will want to say a few words, but essentially the HCBS settings rule that is the topic of tonight was a rule that was published in 2014. So it first came out a long time ago. We're looking at 9 years. And it was supposed to be sort of a short-term implementation of 5 years that was twice kicked down the road, largely because of COVID. And then it wasn't until I think kind of this summer that the feds were like, no, we're tired of this. We're actually going to implement this on March 17th, 2023. So were people kind of caught off guard? I would say yes, partially because we were still very much in the pandemic. And I would have bet that we would have gotten another extension out of it, but we didn't. So the due date is coming up. That said, there's an important concept here that I think we'll have a chance to talk about over the course of the evening. And that is, CMS said there are certain things that are absolutely in play March 17, 2023. So, look at your watch soon. There's other things that we have to acknowledge while a state may be ready. And by the way, we are going to say we are ready because we need that federal funding. But, the issue here is they did agree that there's certain things that because of the pandemic, because of the crisis in the direct care workforce, which is not just New York State, it is literally nationwide, that there are certain things that you're going to need more time on. So while we say the deadline is March 17th, it's important to understand that we have requested a cap, which is just going to give us kind of more time to get there. And I think we'll have a chance to kind of unpack that a little bit, but I just wanted to be clear that we're still going to have this kind of staggered due date. And by and large, I think, just to preface what the purpose of the rule was, and this is something I think Beth can add to, it was really stemmed from the disability rights community. And so in principle, we should all really be supportive of the rule. It's a great rule in terms of the expression of rights for individuals with IDD. Like so many things with CMS, it's the details that become the issue.
Mhm.
And that's what we'll kind of try to unpack a little bit tonight.
Yeah, I was going to say that what we do know, which is pretty limited throughout the stakeholder population, is confusing and anxiety producing. And a lot of it doesn't, from what we know, seem to match a lot of our members of our particular community, which is a thing. So I'm going to turn it over now to Rochelle on more of these points. You're muted, Mich.
I see. I will unmute myself. Thank you. Okay, so I think, I think we can safely say that most people in our community support the overall goals of the settings rule, which is to increase community integration and to approach things from a completely person-centered perspective. But as you already said, the devil is in the details. And I'm paraphrasing, but there is really a lot of concern with the specific ways that CMS is asking us to interpret those two very important goals that really, I think we all cherish, in fact.
Yeah.
Want to see expanded for individuals with IDD. So, and one of the main areas of, I think, of anxiety for everybody is how do you balance the rights of individuals for optimal integration and optimally meeting their desires for integration, and balance that with their health and safety needs, and also with the needs of all the other people they live with potentially and interact with. So what I'd like to do is explore a few specific areas that are part of the settings rule. And also, when you all respond, if you could also address how this might or might not affect people in self-direction as well. Because we know it applies to all the certified settings, like certified residential settings and day habs and employment programs, but we really don't know exactly how this affects self-direction, and that's a concern for many of our audience. So, so I guess, we started talking, I think, among ourselves a little earlier about one of the things that CMS seems to want is to avoid institution-like settings. That's a key component, yes?
Yeah.
So what does CMS consider an institution-like setting? Let's start with that.
That is a very good question. So the first kind of cut at that is, and let's be clear, CMS is not saying we will not fund institutions. They're just saying you can't run an institution and call it home and community based. Okay. So just like we have ICFs, their state plan, they are an institution. They are not subject to this rule because they're not an HCBS setting.
Okay,
So
so
I just think-
just to interrupt a second, ICF is an
I'm
intermediate.
sorry.
Yes.
ICF is an intermediate care facility for the developmentally disabled, ICFDD. It's a type of residence that is institutional, which means, it's one big package of services. Most services, almost everything short of hospitalization is part of that residential package. At one point in time, everybody with IDD who was served in a residential setting was in an ICF because that was all we had. So when we implemented the waiver way back when, 30 years ago, something like that. Yeah, I think it was like the same year my son was born, so I should be better at this stuff. That was when we sort of started IRAs, CRs, all those services that are HCBS waiver. So I just want to make that clear because I know that a point of confusion sort of nationally is that CMS is defunding ICFs and similar programs. They're not. So to answer your question, which was what is an institution? What does CMS consider institutional? Well, very clearly, institutions are nursing homes, long-term care hospitals, psychiatric centers, and ICFs. You know, we'd all say we agree. The other thing that is part of this rule where it gets a little interpretive, maybe, and Beth, jump in, is that an institutional service in this view is not just the ICFDD, the nursing home. It would be any setting that acts like that would limit someone's participation in the community, that would limit choice, that would have a program that operates regardless of someone's kind of, individual needs, desires, wants, right? Like, frankly, they're great nursing homes, but they're all going to have, meals at set times, and it's going to be a regimented life because that's what a nursing home does. So it's a little, that's the benchmark. HCBS can't be institution, but interpreting that sort of institution-like quality really comes down to, an HCBS setting that acts like an institution is not accepted. And I don't know, Beth, you're a lawyer. Am I doing that justice?
Yeah, no, I mean, and I think just from the advocacy perspective, when you think about the HCBS rules, which, I have to say aren't really different than what New York State has been operating under, at least in terms of the regulatory structure, the Willowbrook injunction. The feds and a lot of locations around the country said Olmstead was decided in 1999 and it's 2014. And we do not have actual community-based services for people with a range of disabilities. Because remember, HCBS is funding a variety of programs. So the settings rule, and this I think goes to some of the points people have made, they don't seem to fit well with the population served by OPWDD. And that's because it's intended to serve elder folks, people with mental illness, people with developmental disabilities, children, and the like. So, you look at the feds as sort of trying to kickstart Olmstead into actuality. And what has been sort of put out there by the feds, and there were a lot of comments, people were commenting on the federal proposals back in 2014, is a very sort of non-person centered checklist, right? And we'll get into the issue. You need a key, you need a lease, you need a document.
We'll go there in a
So,
minute. Yeah.
Olmstead, I saw a question pop, is a Supreme Court case from 1999. It dealt with deinstitutionalization issues, and it established on a federal level the concept of least restrictive setting. New York State has been operating under a least restrictive setting since we filed the Willowbrook case. My colleagues, I wasn't there in 1972, but Willowbrook is part of like the advance wing of the disability justice movement in this country. And, the injunction says that class members are entitled to services that are most appropriate in the least restrictive setting. That ultimately was elevated to the level of the Supreme Court. And we have the Olmstead case. With Olmstead, there's an unfortunate off-ramp for the government to say that, if you're forced to provide community-based services and it works a fundamental alteration to the state's service system, the state can defend on that basis, which is why it's really important to keep the federal fundings and the match in place so that we
I think
can,
we all want to
OPW
keep
can develop new services, right?
The other thing we all agree on, we want to keep the federal money.
Yeah, we want to keep the federal money. Yes,
I
we
don't
do.
think anybody is disputing that. Everybody wants to keep the
Yeah,
federal.
exactly.
Yeah.
But I guess I want to probe a little bit from the perspective of what's been making people very nervous and what we've seen discussed in our community for several years now. And it's the issue of size and scale, because size does matter, it would think. And so does CMS want to restrict the number of people who live in a residential setting? There are people who prefer to live in larger group homes. They find that more conducive to their needs and desires. And yet that seems to be something that this settings rule might oppose. And also things like intentional communities, like Camp Hill upstate, and other campus settings. And these are things that individuals and families actively want and have asked for.
Mm-hmm.
So how do you fit that together?
So-
Are we all going to be out of compliance?
Oh, no. So yeah, it's a very interesting point. And I will say it has kind of evolved since the 2014 first implementation. CMS initially came out with all sorts of things that it's presumed institutional if it's this, that, or the other.
Mhm.
And in the, that was during the draft, the first sort of initial publication and comment period, which was struck from the next version. So the bottom line is CMS has not weighed in on size. And so size for them is not necessarily an issue. However, I just want to be clear, just because CMS says, doesn't set a rule, doesn't mean that, you're free and clear to do whatever you want, come up with a 300 bed IRA, like, no. And CMS, if they came into review, would never accept that. But they didn't set a limit.
Mhm.
That said, we, in our HCBS waiver agreement, which is a real page turner, all 400 something pages on our website, happy to share the link if anyone needs to fall asleep tonight. We do have to say what the limit is for our group homes, and it's 14. So in New York State, that is the limit for a certified setting. And CMS has declined in terms of the HCBS settings piece from using that as any kind of measurement stick or benchmark. But I do want to be clear, that doesn't mean the sky's the limit.
Okay.
And I think we would all say, yeah, we don't want to see a 300 person IRA. Like
Right.
that would be
Exactly.
a bad idea.
So that was fairly specific, and that caused concern for a lot of
And then
people.
you had raised, you would raise the issue of intentional communities.
Mhm.
And I did want to just address that quickly. I don't have a real answer in it, in that we're still sort of really looking at the policy. It's a complex issue. We do have communities in New York State that are intentional communities that serve the DD population. Camp Hill, which many of you probably know, is one that comes to mind. What we do with Camp Hill, OPWDD, is we do support them with state payment. So it's not a waiver service, but we do, we have a contract with them to support the folks in that community. But we have declined to enroll them in the waiver largely because, well, we can do so financially with just state dollars. And also it really doesn't, it's just a struggle to understand how a community like that could really be construed as home and community based. But it's not like we don't support it. But I think, it is a broader issue and we're still kind of grappling with it. And, unfortunately, that's probably all I can really say. But it's not an issue that is necessarily strictly related to the HCBS settings rules. We have other laws and rules in place in New York State that we also have to consider. Hence, it's a complex issue.
Okay, I'm going to move on because this is very complicated. We could probably stay here for another hour and still not understand it completely. So one of the things, one of the stipulations that, as my understanding is, that individuals who live in certified residences must have unlimited ability to access their homes and the right to a locked room for privacy.
Mhm.
Correct?
Mhm.
Okay. So the interpretation, I believe, is that this means that all individuals who live in certified settings must be offered the opportunity to have a key to the home and also to their room.
Mhm.
Okay.
Yes.
Now, this is where we get into issues of safety,
Mhm.
and does this one size fits all,
Mhm.
That,
which
you
is
know,
not really very person-centered
Right.
requirement, really work for everybody?
Right.
So how do you address things like people who cannot safely manage a key and might lose it all the time or give it indiscriminately to strangers on
Yeah.
the street?
No, yeah,
Or
Yeah.
you know,
I've
things-
often said that if I had a key to my bedroom and it was locked, I would probably sleep on the couch for the rest of my life.
Exactly.
So this is one of those points, and it's a good one to delve into because I think everybody is fairly, you know, it's a point of contention, right? It is in fact in the rule. So it's not just we're making it up, it's in the rule. And this is one of those places where, God bless CMS, we love them, we love your funding, keep it coming. This is where I'm like, the principle is fine. We've always had a principle of, you know, freedom of movement, freedom of privacy, always, always, always in New York State. As Beth said, you know, New York, Willowbrook, we are way ahead of many, many, many other states in the nation in terms of the basic principles of rights. So the annoying thing about this is we have no argument with the principle of privacy, for example. The problem is CMS went so far as to prescribe the solution, and it is in regulation. And that's where, frankly, yeah, I'm not even going to go there because this is going to be recorded. And
We'll let Beth
Well,
go.
I did want to say though, that, you know, notwithstanding the checklist of, you know,
Mhm.
you need to have a key, you need to have unlimited access to food. You need to be able to have unlimited visitation, you know, of friends of your own choosing. There is a major caveat at the back end of that laundry list, which is as is appropriate to the person and their abilities. And it has to just be documented, right? You cannot have a group home that says no one comes in, no one goes to the kitchen, everyone goes to bed at 6, and you all share rooms and we can come in whenever we want, right? There has to be documentation. If a person in a group home has pica, or a person is unsafe with knives, you know, you document the fact that there is a restriction of rights, and New York State has documented rights restrictions from the beginning of time. You know, there's a whole protocol for that. So part of the negotiations and the education of CMS over time, because remember, this settings rule was really being pushed in the first instance to ensure that people with mental illness who were living in adult care facilities were not treated like institutional types, right? Where they were locked away, locked on a floor, no keys to their bedroom, no privacy, no visitation, no outside effort. And it was Bazelon Center, which is the Bazelon Center for Mental Illness out of DC, who we work with all the time. But there was a really intense period of advocacy and education around the fact that you, in fact, this is not dignity of risk. This is actual risk.
Yes.
You know, I would love for every person in a group home to have their own bedroom, you know, and that doesn't happen, right? And you know, you always are trying to balance the rights of individuals. You know, we have had, you know, folks where family members have come in to the group home at 2 o'clock in the morning, you know, and they come into a bedroom where it's shared space and, you know, disrupt everything. So it is a balancing act, but there has to be consideration. There has to be an offer. We offered a key, or Susie, you know, will eat the key, or Susie, you know, will give the key away, or it will be lost. It will create risk and danger to Susie and others. So it's really a question of ensuring that the residential provider, the day program provider, any HCBS alleged, right, least restrictive setting is in fact assuring that individuals are living their lives to the fullest extent that is appropriate for them, right? And then you get into, okay, we got 14 people in a group home.
Right.
How do you balance those rights? OPW has been balancing rights. You know, we may not all like where they come out, but, you know, this isn't new for the providers, which to me is the most disturbing thing, that there is such hoopla, because, you know, 633.4 of the OPW regulations have been in place since 1985. And they were promulgated in connection with a big hiccup that occurred in the Willowbrook litigation. So it isn't new. I think it's just the prescription.
Yeah.
You need a key, you need food, you need access, you need visitation and, friends coming
Yeah.
into your room, which is a little bit foreign in terms of how things play out for our folks for whom we advocate, our loved ones and the like.
Yeah. No, I think that's exactly spot on. I mean, no matter what you do, a right is not going to work for 100% of the people, right? There's no expectation it ever would. It should always be person-centered. And the only thing to note, and we can talk about it a bit more later, CMS prescribes its keys. CMS also prescribes a process called a rights modification. So if you can't have a key, you may want one, but you're just not safe with one. Then it has to be documented. It has to be part of the discussion that should happen routinely or more frequently if needed, via the life plan, to talk about whether that's changed. So the bottom line here is people have these rights. Providers cannot just say blanketly, everyone in a home cannot have a key and walk away and never have it discussed with the person, the person's family who care and are involved with them. It is a right and it has to be engaged on a person by person basis. But it does not mean that every single person in a group home, as of March 17th will have a key, because that isn't a thing.
Okay, so I think it's a helpful framework that you have been laying out in terms of a process for rights modification when it endangers an individual or others with whom they are engaging. This would pertain to the other elements beyond keys, to unlimited access to food, which is one of the stipulations, which, if someone has Prader-Willi, you got to think about that pretty seriously.
Yeah.
Or other safety measures for people with behavioral concerns. If they're aggressive, they really can't be near the knives and things of that nature. So I think you've laid out a framework, and I think we could give a million examples, and everybody here could bring up more examples. But what we're really trying to find is the framework for resolving them.
Sure.
And you talked about engaging the circle of support and engaging the providers, and very importantly, also engaging the care manager during the life plan
Yes.
discussions.
Yes, that's a very good point. So if, for example, and that would work both ways, right? So if, if the discussion is being had for your loved one having or not having a key, and, the support system says this is really not a good idea, then, absolutely, that's a discussion with the care manager. That's where that should happen, and the provider agency. And, in a perfect world, everybody agrees, the person doesn't want a key, it's all fine. But it's that process. And people should be aware that just like today, this is not new, as Beth said, not new for New York, maybe new for certain other states that I will not mention, some of which I got my master's degree in, but that's okay. It's the same process you've always had. You raise it with the agency, you're concerned with the house manager, you go to the care manager, you raise that concern. That process, your concerns or your loved one's concerns have to be documented and dealt with. It's not okay for an agency just to say no in 2023, and it's going to be no, for the duration of time. It's something you're always looking at. It is a right, and you're going to say, what can we do to help the person be able to exercise that right? It's never blanket, and it's never forever. It's the part of the ongoing work of person-centered planning.
And we're going over the time for this section, but I do want to ask what I believe is the $64,000 question. So, given the severe staffing shortage, how can an agency reasonably address all the varying community integration needs and desires of all the individuals in that program?
So, great question. And you remember I mentioned up front that we requested a corrective action plan, a CAP. Again, it's a standard of HCBS. We want our money. Thank you, federal government. And so And frankly, we all want people to have, you know, the level of engagement and activity. I mean, it's just what we want, right? But we requested the corrective action plan from CMS to say, we need more time. We're dealing with some really fundamentally big issues, and we need more time to get better at it. So we're doing things like, you know, really looking at the wages paid to direct care staff, trying to do our best to, you know, in a million ways, trying to improve that situation and improve the situation of direct care staff who are so critical. And we totally understand. It's not like we can wave a magic wand and all of a sudden, you know, a residence has a one-on-one staff opportunity to take someone, you know, to the mall because they want to go. It's just, it's not the way it is. So that's why we did the cap. And I think everyone fully recognizes it. But again, it's a federal requirement. It's also, gosh, we wish we could do that. But that cap will at least give us past March 17th, we're hoping a little bit over a year to get better. Because we look at data pre-COVID and now, and we're not where we want to be. You know, we all want to be better in that regard. We want to have better staffing. We want to be able to sort of return to, you know, I hate to say normal, but what we would really have considered normal. And the cap is recognizing that. And I think agencies may feel a lot of stress about it. But I think we're really trying to approach this as a community, because I think it's literally everyone, to try to kind of, you know, get better, because ultimately we recognize we need to be better there.
And just from the advocacy perspective on engaging with and making sure that people who are in these confined settings actually have some choice and have the ability to do something that's meaningful and recreational. You know, normal isn't, you know, pre-COVID, normal isn't good enough, I have to say. And, you know, just because, you know, one of the problems I think is that we ask the direct support staff to do everything. And when I first came onto the Willowbrook case, there were nutritionists, there were cooks, there were community hab specialists who sat with the staff and helped them understand what getting out into the community could look like for people. You don't have to buy a ticket to go to a Broadway show or to go to, you know, a sports event or something. There are lots of ways for a person to have community presence that can be done without stressing staff. Just walking to the park, you know, going outside, being in the neighborhood. And so from an advocacy perspective, you know, normal wasn't normal. I mean, we used to have a rule in Willowbrook, and literally it was a rule 3 times a week in groups of 3 or fewer. Otherwise, an agency was not compliant with the community integration mandate that's in the injunction. And we didn't think that was person-centered, nor did the state. So I do think that there are ways to engage and assist agencies to make it fun and rewarding for staff too, because it can't be fun for everyone to be locked in a house 24 hours a day.
No, and I will just add, I know I'm probably way over time for this section, but you know, that's something we're absolutely looking at during the cap period, is sharing best practices, because I think Beth made some very valid points about what being engaged in the community means. And there's some agencies that really have some very creative solutions. So we want to make sure that they have a, you know, that we all have that learning opportunity for best practices among providers.
Okay. So people are asking, I see from the chat, a lot of questions. What's the cap? Just to reiterate, it's the corrective action plan where the state has asked permission to have more time to figure out how to meet all these expectations.
Right. And the cap, we couldn't request cap, corrective action plan for everything. So what we asked for was community integration, community experience, and employment for individuals with IDD. Those are the 2 areas. Having been involved in corrective action plans, that's plenty.
Plenty.
It's a lot of work.
So I'm going to turn this over to Carlene, who's going to spend some time talking about occupancy agreements.
That's fun.
Everyone's favorite.
Okay, Good evening, everybody. So I'm going to violate the rules just a tad. And before we leave this stimulating conversation we just had, I know coming into this, we got a lot of questions in the registration about the impact of these rules. And I just wanted to make sure we nailed down where this is applying and where this is not applying. And so Kate and Megan, when we talk about a cap or an extension of time to comply, we have a lot of folks in the audience who may have individuals who are not in residences, who are receiving day services, both, you know, some without walls, some site-based. And specifically, I guess, on March 17th, when CMS says, you know, you guys, you're out of time, but, you know, maybe I'll consider your cap. What about the site-based programs and the others? Are they under the CAP or the corrective action plan?
Okay, very good question, but let me just back up 30 seconds because I need to sort of lay some groundwork here. This is a huge rule. I mean, people have asked for a one pager. It's like 80 pages of reg. I can't do a one pager. Nobody can. So if you get a 20-page one pager, you can have a one pager. But there's a whole series of rules that apply to everybody who gets HCBS. If you live at home, if you just do day hab, if you live in a residence, it applies to everyone. Dignity, being, not being secluded, the stuff that, oh my God, I hope we're not, I hope we're better than that. But that applies to everybody. There's another set of rules and requirements, keys to bedrooms, right? That only applies to residences. Occupancy agreements only apply to residences. So when you say, does all HCBS have to be compliant? The answer is yes. You have to treat people with dignity. They have to have choice. They have to have person-centered planning. That is everybody. What we were talking about, which was, keys to bedrooms, occupancy agreements, that is sort of expanded rights in a residential setting. So special rules for the residences, but it does apply to everybody. So, day hab, yes, the expectation if you're in a site-based day hab program isn't that, and it never has been, right? It's never that you get on a bus, you go to day hab and you never leave day hab. I mean, the hope is that you are involved in the community and that it is meaningful for you. Obviously in the middle of winter, I get it, but it's always been an expectation in New York. So things like the community, the extension for community engagement may very well be needed for a day hab program that, for whatever reason, staffing,
So
whatever needs more
to
time.
be specific though, so that folks know, if I send my person to day hab, Rochelle asked the $64 question, $64,000 question about the staffing. So there's limited staffing, exacerbated by, the pandemic, et cetera, and everything else. And, all the issues we know. Is New York seeking an extension on community integration, get those folks out, okay? Getting everyone out in the community, making sure that they have meaningful activities in their settings. Are you requesting an extension of time on that? I think that's the 64. That's what, yes, it wasn't clear to me when I was reading what I was reading. Yeah.
Sorry about that.
Yeah.
So the cap applies to everything. Now, obviously, if you're not engaged in employment, it doesn't really apply to you, but it might if you want to be employed. But yeah, the community integration is not limited just to res hab or residential settings. And sorry if I wasn't clear.
No, I know it wasn't you. It was, I think it's the nature of the beast. I understand it. And that you have a lot of overlap here. And with the principle that the rights portion of this applies to everything. And I think, we've had a good discussion on that. So I want to move to something else. I think we talked about checking boxes here and about the feds being specific. And I think there's another area, and we're talking about occupancy agreements, right?
Don't you just love a good occupancy agreement?
Yeah. So I guess what I want to make sure is I get some input from, all you guys, because I know that very interested in I guess when I get to the next section, how these will be, you know, on the enforcement side of this. So I'm looking at Megan, but generally, I guess, let me start with Beth. Beth, occupancy agreements. You know, when I saw this, I started scratching my head because I said, okay, if this is about individual rights, why are we talking about an occupancy agreement? Sounds like a landlord and tenant. It sounds like my lease, right?
Exactly.
So how does this fit in? How would you best explain it to a parent who's just looking at this and saying, why is this even in front of me?
Right. So you're exactly right. I mean, and it is every person's sort of got a right to evidence that where they're living, they're entitled to live, right? So if you rent, you have a lease. If you own, you have your deed. And remember, originally what I said was this was to deal in the first instance with adult individuals in adult care facilities for people with mental illness, where they had absolutely no rights against their landlords, right? It does not apply to a group home setting because remember, in New York, if a provider or the state doesn't own the property and is renting from a landlord, there are major questions about whether the people that live in the group home are subtenants, right? Are they licensees? I mean, you know, we could go on and on about real estate and we won't, but the intent, the intent was to give people, you know, a piece of paper that showed they had a residential right. They existed just like anyone else in the community. Devil in the details. How does that work in a group home? What does this mean, right? And from where I sit, OPW don't need to cover their ears because they've heard me say that what I'm concerned about with the occupancy agreements that we've seen, and because we have 1,800 Willowbrook class members who are living all over the state in pretty much every region for sure, in some of the larger group homes, obviously, because they were the first wave of people to be placed in community. We have seen a number of occupancy agreements that effectively are weaponizing the HCBS settings rule because they're not saying you as a person who is living in a residential setting that I'm charged and obligated to provide to you have to listen to what I say because I'm your landlord, as opposed to you as the resident of this house have all of these rights. There are some obligations. Yeah. I mean, you know, 633(4) doesn't say carte blanche. You can paint, you know, your bathroom orange and blue because you're a Mets fan or, you know, which a class member did. I don't know why I'm from Boston originally. So, but, you know, at the end of the day, you know, there are certain, you know, restrictions, but they're not restrictions that we've seen in these occupancy agreements. You must participate in your treatment plan. And if you don't, your care manager will help you find a different place to move to. These are documents that engender an enormous amount of terror, you know, concern for a person who signs for themselves to read something that hasn't been reduced even to, you know, sort of plain English. These can be very, very traumatizing documents.
So with that though, looking at Megan and Kate, is OPW, do you have a plan to assist providers in their efforts to
Yes.
comply with what is a federal requirement for you, right? Not your
Yep.
idea, I guess.
Exactly.
Right? Not my
Right.
idea. But now I'm in the middle. I have to make sure, yes. So what are you doing to make sure that providers are not weaponizing or putting terms in agreements
Yeah.
that probably CMS never intended go in these agreements because they saw them as being rights enabling agreements?
Exactly.
And not sort of agreements that would basically appear to give, I don't want to be too harsh, a provider some sort of leverage that they should not have. certainly not in this context,
Absolutely.
which might even be inconsistent with other rules and regulations and statutes.
Yep. Yep. No,
So-
absolutely.
So
It's,
please,
yeah, it's a
what are
very,
you doing to help
what are
them?
we doing? Okay. It's not just us, okay? CMS thought this is so easy. Nobody could get this wrong. They started visiting states and they were like, oh my gosh, this is terrible. And then we were like, oh, you better start looking at this. And lo and behold, they weren't all that great sometimes. So bottom line, we are working with Beth and others on a template that will be used in our residences. I think we sort of had a version, we're getting better. That will be on our website. We are issuing an ADM and our hope is really, really soon it'll be out for public comment. I think Beth and others have a copy for review that will instruct providers, you can do this, you can't do that. If you have an agreement that doesn't comply, you better redo it. So
So let me stop you right there.
Mhm.
Are you you're serious about that? If you have an agreement that doesn't comply, you better redo it.
well, I mean, if somebody, let me stop there because there's an important concept here. Whether a parent signs it or doesn't sign it does not affect the tenancy in the house. So, if you're really concerned, you need to raise the issue with your provider and explain to them that you have a concern with this particular thing that looks like a rights restriction, or does not comport with law or reg or rule in New York State, and that's extensive. So every single protection that exists in rule and reg and law today exists whether or not you sign that agreement. Now, do I want people to sign the agreements? Yes, I do, because it's a compliance issue. And I would love, love, love if we could get really close to everything, right? That would be great. That said, we recognize there's work to do. We definitely want to get more guidance out there. I think, frankly, probably my fault. We were caught a bit flat-footed, just because I think we sort of thought this wasn't that hard. But it is a complex issue. But I think families need to understand this will not affect your loved one's rights. Nothing in that agreement is going to have any sway in whether a person can safely continue to be served in a particular setting. And if that is the case, there's rules already in place, long in place in New York that already govern that. So it really, in my
So
mind,
I could ask you where for the concerned parent
Mhm,
awaiting the ADM.
mhm,
And I think I've talked to maybe you, we've talked about this at New York City Fair,
Mhm.
and we'll probably ponder this later. We really would like to be able to offer some sort of guidance.
mhm.
And of course, it's best if it comes from, all of us and certainly from you.
Yeah.
Where should folks go?
So I think first and foremost, we hear you and we're definitely looking at getting much better in our public presence, particularly from an individual and family perspective. And this is an important one. So we have folks that are working on a plain language version of that template so that people can really understand it. That will also be on the website. Again, all works in progress as we speak, but I think we all really feel the pressure to do it quickly. But again, if you feel that there is a rights restriction in there, like you must go to Dayhab or, something else that is just would be a restriction. First of all, understand it's just not an issue because we have rules and regs and really marvelous protections in New York State. And this agreement does not trump any of that.
Yeah, and I think what's important to point out, because I think a lot of the angst, it centers around what you're saying, is the E word.
Yeah.
So in landlord and tenant, it would be called eviction.
Right.
In this, it would be determined, it's time for you to leave the residence. And but for these occupancy agreements, I think Beth could rattle off all the rules and regulations which have
Mhm.
applied in New York to protect someone.
Exactly.
Right.
Yeah. So I think it's
for a
really
long
important that people
So
get
I
that.
think what it's important to try to figure out how folks cannot be concerned that these agreements are trumping that.
Exactly.
Am I hearing you saying the ADM will do that then?
The EDM will do that. It will very clearly do that. And, you know, some of the other materials that we're looking at, the template, the plain language document will all communicate that. So I think,
Yeah. So Megan, I know you're responsible, and I know that's not all you're responsible for, but a big hat you wear will be compliance. And this is a difficult one. So from a compliance perspective, providers are have time to get these occupancy agreements signed then, I guess, right?
Yeah,
Because
so I mean, the occupancy agreement, the template that we're talking about that we are, you know, close to hopefully very, very much in the near future releasing. We are not requiring that template. Some providers already have very good templates they've been using for a long time. They're very good. They don't have to like redo and use our template. Many may choose to use that, you know, or switch to it. But that will actually be not a required template, but, you know, a recommended document meant to be helpful. So that's one thing. And then in terms of compliance, I don't know if this is premature for me to kind of jump to the DQI activity and role that we play. Do you want me to hold on that?
no, don't hold, keep going, because
Okay.
these topics flow into it, and I have both topics to discuss with you, so keep going, that's fine.
Okay, so
Say
the
what
We can
division-
go back and forth, you know,
there we
the
go.
words, yeah.
The Division of Quality Improvement,
Mhm.
folks know, OPWDD has, survey staff that go out to the programs and do survey and certification visits. And what we did with the HCBS settings, compliance is we wove the settings standards and requirements into our survey protocols back in 2016. So it was many years ago, right? They were put into the actual survey process and protocols. So when residential programs were visited, other than the ICFs, and when day habilitation programs were visited as well, we were looking at the setting standards, okay, as part of our survey process. Now, initially, we were not issuing deficiencies, you know, in a formal statement of deficiencies, but we were making recommendations to providers, you know, with the, you know, intention that they would, you know, correct or remediate whatever it was. You know, we document it in an exit conference form. And then, of course, we had the public health emergency. We had COVID, right? And I think obviously as a system, we all got set back here. But I do want to just, you know, clarify that there's been, you know, many trainings that were done and through the years and resources put out. But we all got derailed from it, right? For obvious reasons. So now we've had the refocus in 2022, 2023, where as we go out to survey, if we see a settings requirement not complied with, as we look as DQI surveyors do the protocol, if something's not met, then we are issuing formal deficiencies in statements of deficiencies woven into our existing process. And then providers then are submitting corrective action plans. And we in turn also do need to ensure remediation. So we can't just take the plan that says we did training or we added keys into our program or whatever it is, right? We actually have to see it, verify, make sure, right? We have to take it to that level. Importantly, you know, most of our programs and system are complying with the settings requirements. We are not fully 100% compliant everywhere. It is a fluid situation, but we are actively focusing on getting to the point of full compliance for March 17th, knowing that with the two issues that we have identified in the CAP, that we're expecting to get the approval to have an extended period of time, because as we all know, the community integration, access to the broader community is, you know, really our top challenge that we're facing with the workforce challenges. So that's what we're doing right now for compliance. And I think, you know, what we see is things work best when we weave it into our existing systems and process.
Mhm. So with the concept that we talked about of having the rights, and, you know, Rochelle had brought out the issue of keys and the issue of access to food and the issue of privacy, which may or may not now, because they have been called out and put up front, require that there be rights modifications. What are the compliance folks looking for when, say, they go in and they see that 2 individuals of the 4 in the group home do not have access to keys and they have not been given access to keys? What are you looking for?
So as you know, just as part of our regular survey process, we're reviewing documentation. We're looking at someone's life plan or their care plan. We're looking at the staff action plan. We're looking at further documentation that show that the person, their family, the team was engaged and that these rights were offered and discussed with somebody. And then there's documentation for any exception to that. As part of a rights modification process that honestly, we've had in place as a state agency for, I can't even tell you how long, Beth, I don't know if you even have any idea.
1975. I mean,
1975, yeah.
seriously, it has been, that's why I keep saying I don't quite understand what the disconnect is here in terms of what's going on, right? I know there are a lot of questions about what do you do if you've already signed a document like this? And, obviously, my Willowbrook class members are in a different posture because we have a federal consent judgment. But I do think, having been to treatment team meetings over the course of the last 9 months, there isn't a bedside manner for the presentation of this document. It's basically slapped on the table in front of the advocate, the person, their family. I think people should say, thank you, I understand where this is coming from. Take the document so that you can read it. There are a variety of ways to approach things. You can sign and say, I do not waive any of the existing rights, right? I don't waive any of my existing rights if it's a person who's signing. If you're a family member and you're asked to sign it, you're not waiving any rights. I understand this is not a waiver of any existing rights. I think knowing that this document is not a weapon to be used. You don't want to get into a fight with your provider. No one wants to have tension in those settings. But I think if OPWDD is sending the clear message that whatever you've got written in there doesn't vary, it's not a waiver, can't be used to evict a person, carry on, right? And we're working on whatever we're working on. Again, it is a very difficult situation because it has not been explained well. You're asking, oftentimes it's a residence manager who sort of runs in at the last minute at a treatment team meeting.
Yes. So, Beth, I think we're getting a question, and it is inherently hard to try to figure out or characterize. Okay, so a good term would be, a term that reinforces that as an individual in a home, you have a right to privacy. You have, a rights recitation in the occupancy agreement. Am I right, everyone? Can we give individuals an example, just one example of something that probably should not be in there?
If you don't comply with your treatment team, if you're with your plan of care, with your behavior support plan, your care manager will assist you in locating an alternative residence.
Okay.
Right.
And you're
that should not be in there.
Okay. I just wanted to give one flavor because, I'm trying to look at the chat too.
But there are also sort of lesser flavors because I know, having seen, and I think everyone has the same experience because there were, the provider agencies, much as we see them, as a monolith, the New York Alliance didn't do a template document for all the members, right? So each provider had their own attorney trying to navigate landlord-tenant law. In New York City, we've got much more intensive landlord-tenant provisions than upstate or out of the city on Long Island. So you have this mix of things, all of which have some problems to them. So people will see things like, if you bring people into the house, you will leave, right? So it can be as benign as flipping what the HCBS settings rule says. You have the right to unlimited access to food. You have the right to, privacy. If it says you don't have the right to privacy, that's a problem. Some of them they're not as obvious in some ways. That's why I say, take the document. No one should be forced to sign anything. You always, as a lawyer, I always say, do not sign anything until you've had the right to read it, ask questions, and be satisfied that you understand it. We have language access issues. It's only offered in English. So that's another major, major problem for a lot of the families in the city.
Okay, so what I think a takeaway before I wrap this part, which is kind of melded into the next part, but they're related, nothing is unrelated here, is folks should wait and take a look maybe at the ADM, but for those that, me included, don't like reading those ADMs, find them difficult to read, one should not hesitate, right? In contacting their care manager, contacting OPW, and not hesitate and think that, okay, here I have an occupancy agreement, I'm in real trouble here. Yeah. So I think that, hopefully that guidance will come out very, very soon. And so folks can, be where they are, because if I'm hearing right, the providers know that when they see it, they will have to take a second look at what they already have out there.
Right.
Yes.
Which
And,
would
and
be,
I think we have to allow some time for this to be fair, right? This has been in New York State regs since 21.
okay.
So it's been a while. And frankly, I was a little surprised that this is one of those elements that CMS fast tracked. I was very surprised by that.
Mhm.
But, so let's all be kind to one another. There's
Okay.
nothing in these agreements that is going to put your residency at risk. It will not. There's rules and regs and law that protect that. And providers are struggling as much as all of us to do this. We didn't find out, I think, till July that this was actually part of the what has to be in place. So, and that may seem like a long time, but that's actually like yesterday for state government. So
Okay.
be kind, read it. There are resources, talk to your care manager, Beth. There may be other resources that would be available in the advocacy community. And yes, there will be additional.
And we'll have further conversations with you guys about resources, because I know that, and I'll wrap up, I know that the intention is to get some materials out to everyone, certainly everyone here, and, in a major blast to follow up on this. And Megan, I appreciate your, yes, Ellie's telling me, we know that we will ask you for the, no.
Yes,
I get
definitely
it.
ask.
She hasn't bought the
Always
book out.
ask. And don't forget,
No, what I was going to say was we will follow up on this. I'll follow up with all of you. Okay. And we'll try to get as much out there as we can.
Yeah, absolutely.
Promise to do that. Megan, I appreciate that concise summary of the enforcement. And what I guess I'm hearing before I leave is some flexibility, I would hope, at least in those aspects of community integration, which you recognize you need more time to do, right? So, yeah, okay. Okay, thanks so much. And I will now turn it back to Mary.
Hi, my job is to do the devil in the details for families who want to know how they have, what they need to do to document the things that do not work for their particular individual, whether it's the knives or the food or the access or the keys or whatever it is. What documents do they need to have? How do they write it up so that it passes scrutiny? And does it all have to be done by March 17th? Because that's, you think July was yesterday. March 17th is next hour.
yesterday.
Yeah, it's in about an hour.
Yeah, exactly.
Exactly.
I
So if
mean-
you could be very clear about that and very specific, so people can actually write this down and create their own little template for these specific things.
I do think that, one of the things that people should look at is, are there any existing rights restrictions, right? And, do you have a bed alarm? Is there an alarm on the door to your bedroom? Is there an alarm on the door to the house? Is there a gate to the house that locks? Those are all rights restrictions. Do
Right.
they apply to the person, all the people in the house? Like, does your loved one in the home need that or not, right? Because, originally OPW used to cohort people by, sort of level of intensity of supports, right? Which correlated often to same restriction of right. And we now have a much more diverse population in group homes, right? And smaller group homes, single person settings. This applies everywhere. But if there is an existing restriction, make your little list of what's there. And then think about, no one's ever really thought about, does the refrigerator need a lock on it? Is there somebody in the house that eats the Doritos and can choke? Does somebody have diabetes, right? And can't have access to the Twinkies? I mean, it's like, what goes on in your person's life? Because it may already be documented, right? And there may not be any concern whatsoever other than this. Do you have a key? Do you need a key? Do you want a key? Right? That to me is so weird that CMS is saying, yep, keys all around. I'm like, there are so many other rights that are so critical.
Right.
that
There's
they're-
something up in the air and it's what
Yeah.
came down.
Yeah,
But documented where?
should be in your life plan.
Yep.
It
It should be
be,
in your life
Like
plan.
plan.
The only thing I would say is if a restriction is related to a behavioral support,
right.
which many of them may be, then you probably have a behavior support plan.
Right.
It's part of your life plan. It's all part of that package. And then it probably would be there, which would be appropriate because that's where you're talking about all the supports and services that a person needs related to that
And then
behavior.
most likely in, say, the residential staff action plan as well, right? So it would be really, any questions or concerns is, talking to the team, talking to the care manager, talking to the residential manager, potentially convening if that needs to be done, right? But again, remember, most of this, as we were talking about, we've had the rights modifications process for many, many years. That should already be happening. I think the new twist really is the keys, right? That's kind of a new thing. So I think that's probably it. And then, of course, the occupancy agreement is the.
And the
other.
food
And the food, yeah.
and the
Access to
visitors.
food at any
Access to
time.
Food, knives,
Yeah.
visitors,
That's an
right? You
important-
don't necessarily, yes, everybody can come and go. I mean, there are already so many issues right around access.
Right. Now, the thing about, there are houses that have an alarm at the front door.
Mhm.
And it may be only one person in the house who's an eloper. So
Right.
therefore you're restricting the rights of everybody else, which up until this point, no one else in the house was complaining about.
Exactly.
But now what?
Well, that actually is one of the collateral consequences here, right? Because at the end of the day, someone, people, so many things go into who is in the peer group in the house, right? And so it may very well be that, Cynthia needs the alarm, but Joe and Fred and Susan don't want to move, don't want her moved. So it's okay. How do you document the consent?
Yep.
Yeah.
That is a different issue and it really is not addressed by CMS, right? So
Right.
I think you have to make sure that when you're in, the treatment team meetings, when you're in your care planning meetings, when you're with care managers, and, I gave Jim's comment a thumbs up in the chat. Care managers too, it's just like your direct support staff. Nobody has been led here, brought along, read into what's going on so that, I talk about like bedside manner, but people don't know how to present it because I do think that it's very important if you have an intentional community within a group home where there is a rights restriction tied to one of the peers in the house. What do you say in everyone else's plan?
Yeah.
Because they shouldn't really know, right? Because they don't have a right to know that level, but you need to demonstrate that the house is not out of compliance because people understand and are willing to permit a restriction in order to maintain the relationships. That might not be true, right? You may have a house where somebody, and we've had people introduced into houses with class who require enormously restrictive, and everyone is locked into their room and no one can have any freedom in the house anymore. That's a different situation, right? So you really do have to play it by ear, because at the end of the day, the settings rules and the occupancy agreements, are fine on a one-to-one basis, but when you have people in congregate settings, how do you weigh and balance that? And CMS hasn't given anybody the answer, and that's CMS. It's
Yeah.
I think you raise a great point with the group living environment, right? It's a challenge and it's a balancing act. We did recently, we've been doing different trainings for providers, but there were so many requests around this topic. We did do a provider training back in December, and then we still had many questions come out of it. We did issue to providers a questions and answer document too, to continue to educate and clarify on this point, because it's a challenge.
I think that you have to recognize that this is enormously concerning to vast members of the people affected by it, the families and the individuals, and a huge amount of educating and informing needs to get out there. I mean, we're trying, certainly here, and we're limited by time and knowledge. But I urge you, this is not in my question section, but I urge you to do everything you can to get that out, and to do so in more than one language.
Oh, absolutely.
And try to quell the fears. And because that date is looming, does this have to be done by March 17th? Is that accurate, or is that just kind of a suggestion?
Well,
don't give
technically-
providers an inch.
Well, I'm not thinking about providers. I'm thinking about families that want to be sure that their loved one is protected. From mayhem of all of a sudden anything goes, which is how it may seem to some families, like, oh my God, people coming and going and food every which way, and they have a diabetic child.
Right,
So-
right. Well, the answer is don't panic. The earth is not going to start spinning a different direction on March 18th.
Well, it
Is the
started
rule in
already.
effect? Yes, the rule is in effect. And we in New York are compliant. But I think there's a real, and we're all going to say that repeatedly every day. But the thing that I think is important to understand is Megan can come visit the IRA that I run, which is fabulous. And it's totally compliant when she visits. The next day, I may not be. It's not like we can say, oh, check the box. We are HCBS compliant. We walk away. It's always an ongoing process for every individual and a system. And it's always that balance in a group home setting, which is why Beth's point about, where the rule came from and how it was applied really doesn't work for a group home. So I think deep breath, we will get there. We have always had rights modifications processes in New York. It should always be part of the ongoing person-centered planning process, the discussions you have, with your residents, with every care manager. And you could be happy in March, and in June, something comes up and it needs to be discussed. It's the same process that hopefully, people are enjoying, the right to that process, which I think in New York is not new.
So is there certain language that has to, I'm sorry to get so particular. Is there certain language that has to be used when you say this right should be restricted? Or you can just write it as you yourself speak?
Write it as you yourself speak. Absolutely. There's no magic phrase.
Okay, good.
If you're concerned about your loved one, for example, having a key, you would just, you could write an email to the care manager and say, I really want to talk about this, or to the provider agency, whichever, both, I would suggest. I think you always should have your care manager involved, saying, I don't think this is a good idea for my son. Here's why.
Okay.
He loses things, he'll eat something, he'll, whatever. And then that's part of the person-centered planning process. So, which really, when you think about it, is not all that different than I'm sure, folks are operating today.
Okay. Now there's certain, well, we're getting toward the end. I was going to say that I know people who live at home and people who are doing self-direction have a different set of things they want to ask you that we do not have time to get to 100%. Is there anything you can say to us quickly about how this applies to them?
Sure. So remember when we talked at the beginning about there's kind of two sets of rules. There's the rules that apply to everybody, rights, the general concept of privacy, the right not to be restrained, the right to have person-centered planning. That applies in self-direction. Somebody who lives in a residence but self-directs their day program, their residential services is under HCBS settings because they live in a certified setting, and that includes the occupancy agreement,
Right.
and
Yes.
visitors, et cetera, just like anyone else in a residence. But those day services, there's no specific site-based rules to someone who self-directs.
Right.
So you have all the protections that everybody has, and frankly, in New York State, I would hope always had. That was me knocking on wood. But in terms of, the details that I think folks are most sort of maybe concerned about, like the occupancy agreement, that's for a provider controlled setting. And that's not typically for someone who self-directs.
Right.
Or is in family care.
Right.
Right. I mean, there's certain places where the presumption is, remember, these are all based on how institutional is the setting that you're in, whether it's day, whether it's residential and the like. So if you're self-directing, you have some autonomy, right? You are not institutionalized. You are not in a restrictive setting. I mean, maybe restrictive because there's not enough money to do what you want to do. But, if you're in family care, that's perceived to be less institutional, right? Because it's, you can have breakfast at 9 on the weekends as opposed to 6 during the week. So it really depends on what the setting is, but the touchstone always is the feds are very interested in ensuring that the person is not regimented, institutionalized, denied the ability to engage with the world and their surroundings in the least restrictive way that's appropriate to them. And that's where you get the rights restriction, because remember, the person-centeredness is there is this protection from harm element, which drove the Willowbrook case. And it sort of carries through in this balancing of least restrictive, most appropriate. It's person-centered, right? And so you have to look at the individual, and the system isn't set up to do that well, right? Because there's still too many people, too little time, too little money.
Right. And too little staff
Exactly.
to carry out many of these very desirable things, like getting out into the community.
Yeah, which are
And,
rights, absolute rights, and to not have sufficient staff is, this. Our parents who are still alive in the Willowbrook case are just, I can't tell you how depressed they are. And, Megan and Kate were in today's Willowbrook Task Force meeting, listening to 86, 90-year-old folks saying things that we fought for haven't been effectuated. So,
Yeah, well, things we
Continuous
fight
fight.
for over here at NYC Fair, I have to say.
Yeah.
I think there's a minute or two for questions. Is there anything, let me see that in the chat that we didn't get to, or anybody on the phone? I need help from the Zoom master here. Matthew. He's laughing.
Yes, ma'am.
Or Lynn, is there something from the chat that you'd like to raise quickly? I don't see her.
Well, I got booted about 3 minutes ago and all the chat disappeared for me. So I'm sorry to say that other than what about self-direction, which we got a partial answer about, less impact in general, and not no impact, but less. So no, I apologize. My tech let me down.
Well, hopefully good impact.
Yeah. What we would like, and we're going to follow up with everybody, is resources that people can turn to for more information. A lot is in the chat. Also, we will send the documents that you used for the trainings to everybody to take a look at, which will probably raise more questions. And we will try to get as many questions in the chat that we could not answer at NYC Fair. And I think that's the best we can do. Does anyone else want to say a few words in this? Rochelle or Carlene? Oh, they're quiet.
Yeah.
That's
No,
amazing.
I think you said it all.
Oh, good. Okay. That's amazing.
Thank you so much for giving up your evening for us.
Yes, indeed.
Yes.
And any resources that you are aware of, please let us know and we will disseminate that as well. Because like I said, I think there will be a lot of follow-up.
And I
Well,
putting in
and
a
we,
quick
yeah.
word
Yes.
for if you have any connection with Mental Hygiene Legal Services or Disability Rights New York, they are, read into what's going on and what the concerns are, and they're available. But we'll make sure that, there's more than that sort of labeling of a potential resource.
I believe somebody from DRNY is actually on this
Okay, great.
Zoom. I think I saw their name go by.
Yeah,
in the-
Nancy.
in the chat at
Nancy's
some
on there,
point.
I think.
Yeah, so thank you
Yeah,
very
so we'll
much.
make sure you have that, because I know, you're down here mostly, but, I know there's a lot of people on this from around the state. So,
Absolutely.
Yeah.
And there are questions.
I'll
all-
work with Beth on getting those resources to you.
That's super. Thank you, Carly. And thank you, Kate, Megan.
Yeah,
and-
yeah.
And
Whatever.
thank you for organizing this. I
Yes.
think, I think it's been a very helpful venue, to hear your issues and concerns, and I think it'll help us.
I suspect you'll be
No.
back.
Yeah,
I suspect you'll be back.
yeah, that's probably true.
no rest for the weary.
I
And
think
Ellie,
that's
take it
true.
away.
But yeah, I just want to thank everyone for coming. I mean, we had a full house. 209 people stayed on till now. So, we learned a lot and we have a lot to learn. So to the family members out there, just remember that a lot of advocacy opportunities are coming up and you really need to be present. So read our blasts and we'll follow up on everything that happened today. And thank you to Megan and Kate and Beth. And thank you to Carlene and Rochelle and Mary did an amazing job. And see you next time, which will probably be the budget.
Soon.
Bye, everyone. Thank you.
Take care.
Bye. Good night.
Thank you all. Good night.
Good night.
Bye. Matt, can you save the chat?
I did already.
Super, thank you.